Our first judge is Ariel Atkins. Come on down. Okay. She's a former CCO competitor, graduated from Kent State University with a Bachelor's of Science in Nursing, currently working as an emergency department nurse in Ravenna, Ohio, as well as a nurse counselor at a local Christian pregnancy center. Welcome to Ariel. Our second judge is Stacy Hampshire. Stacy is a former CCO competitor, debate coach for 10 years, I think well known to many of you, and mother of 4 little munchkins, under 5. All right, our next judge is Mr. Mike Ruckman. Also known as the Big Kaboom, I believe. He is a homeschool father. He is CCO and president of Class 8 truck sales. All right, our next judge is David Cahill. Pediatrician in Beaver, Pennsylvania, former debate coach, has 10 kids. Awesome. All right, our next judge is Eric Mishney. Okay. He is the CCA committee chairman. He is head speech coach for SWAT, a former high school and collegiate forensic and debate competitor, and the executive director of Stalwart Theater Programs. Welcome to Eric. Then we have David Isley. He's been a homeschool dad for 26 years. He's participated in competitive speech and debate for 16 years. His professional background involves corporate training for platform and presentational speaking. How appropriate. He is an industrial engineer and is currently a senior manager for inbound operations for a 1 million square foot warehouse. And last but not least, my husband, David Besse. David is the director of the 415 Group's Information Technology Division with a focus on IT, security services, and consulting. He's a graduate of Nova University. He holds a Bachelor of Science in Business Management and a Master's of Science from the University of Maryland in IT security. So welcome to all of our judges.
A national security letter allows the Federal Bureau of Investigation to issue searches of records and communications from a third party without judicial approval. Many include gag orders or suppression, keeping the recipient from speaking about it to anyone. NSLs are a very key tool in domestic surveillance. From Michael German, Michelle Richards, Val Capone, and Steven Siegel, National Security Letters, Building Blocks for Investigations or Intrusive Tools. September 1st, 2012. Quote, NSLs are nevertheless critical tools that enable the FBI investigators to gather the sort of basic information needed as the building blocks of a national security investigations, unquote. For reasons we shall present to you, the affirmative team stands resolved that the United States federal government should reform its counterterrorism policies for the domestic surveillance of U.S. citizens, to be able to use these tools in a manner that benefits Americans. Observation 1, the definitions. All definitions are taken from the Black Laws Dictionary, 2nd edition, unless otherwise stated. Reform. To correct, rectify, amend, remodel. Counterterrorism, the actions and methods of a country that are intended to stop the activities of people who use violence to achieve political aims. Macmillan Dictionary Thesaurus, Online 2013. Policy, the general principles by which a government is guided in its management of public affairs or the legislator in its measures. Domestic, of one's own country, native. Collins American English Dictionary, Online 2013. Surveillance, observation and collection of data to provide evidence for a purpose. Citizen, a member of a free city or rural society possessing all the rights and privileges which can be enjoyed by any person under its constitution and government, and subject to corresponding duties. Observation 2, the harms of the current legislation. Harm 1, massive amounts of national security letters are used purposefully to bypass the courts and can tap anyone relevant to an investigation. The FBI misuses this information. 4 more years, Patriot Provisions renewed, Center for Democracy and Technology, June 2nd, 2011. Quote, the FBI investigator merely needs to claim to a supervisory FBI official that the information it seeks is relevant to a national security investigation. Relevance is a very low standard, especially when there is no independent assessment by an officer. And national security investigations can be very broad because they are not limited to illegal acts, unquote. Signed by 11 congressmen, Congress of the United States, June 6, 2013. Quote, the FBI must show that the information sought is relevant to an investigation, and if the information pertains to a foreign power, the information is presumed to be relevant, unquote. Harm 2. Recipients of national security letters are held under the gag order, which keeps them from saying anything about the letter or its contents to anyone with no time limit. From the Electronic Frontier Foundation National Security Letters, quote, recipients of NSLs are subject to a gag order that forbids them from ever revealing the letter's existence to their coworkers, to their friends, or even to their family members, much less the public, unquote. Michael German, Michelle Richards, Val Capone, and Stephen Siegel, National Security Letters, Building Blocks for Investigations or Intrusive Tools, September 1st, 2012, quote, as the DOJ Inspector General noted in his 2008 report on the FBI's use of NSLs, the vast majority of NSLs, approximately 97%, include non-disclosure requirements, unquote. Anonymously published because the FBI prevented the name from being disclosed. My National Security Letter Gag Order, Washington Post, 2007, quote, living under the gag order has been stressful and surreal. Under the threat of criminal prosecution, I must hide all aspects of my involvement in the case, including the mere fact that I received an NSL from my colleagues, my family, and my friends. I have no choice but to look them in the eye and lie. I have now been under a gag order for over 3 years, and other NSL recipients have been silenced for even longer, unquote. Observation 3, the plan. Mandates. The affirmative team will perform legislation allowing the FBI to issue national security letters, particularly Section 505 of the Patriot Act. Mandate 1. National security letters may be issued if the information is specifically relevant to an authorized foreign counterintelligence investigation of an illegal action, and there are specific and articulable facts giving reason to believe that the person or entity to whom the information is an agent of a foreign power. Mandate 2. National security letters will be issued by the FBI headquarter officials. Mandate 3. Gag orders may be issued with a limit of 30 days. If the investigation needs to continue longer, the gag order must be extended by Foreign Intelligence Surveillance Court. Mandate 4. The FBI may not store information that is additionally sent by an NSL recipient or any other information that is no longer relevant to an investigation. Agency. The federal government and its subsidiaries, especially the Federal Bureau of Investigation. Enforcement. The Internal Investigations Section, which monitors misconduct within the FBI, will enforce this plan. Funding. No additional funding is required. The affirmative team reserves the right to expand upon this plan and clarify as needed. Observation 4, the advantages. Advantage 1, By changing the standards and helping reduce misuse, we'll narrow legislation to truly critical cases with justifiable reasons for the national security letter, increasing the security of our country against foreign powers and protecting privacy of the innocent. Richard Besse, Letters of the Law, ABA Journal Issue 2012, Academic Search Complete, quote, "It's become a data collection tool. It should be a tool to investigate rather than a tool to get as much information as it can," unquote. The gag orders, Advantage 2. The gag orders cannot continue eternally, providing a balance between government security and the freedom of speech, lessening the burden on citizens. Anonymously published because the FBI prevented the name from being disclosed, my national security letter gag order, Washington Post. Quote, "At some point, the secrecy itself becomes a threat to our democracy. The secrecy surrounding the government's use of national security letters power is unwarranted and dangerous," unquote. As we have seen, the fundamental problem remains the FBI's overboard authority to obtain sensitive information relating to innocent people unilaterally without court review and without demonstrating any nexus to terrorism. This imprudently low standard remains an open door to abuse. Michael German and Michelle Richardson. Under the affirmative team's plan, we will be able to use national security letters in a way that protects liberty of citizens through security without being detrimental to their privacy. Thank you, and I now stand open for cross-examination and further clarification.
Hello, how are you today?
Good, how are you?
Good. Now I have a few questions for you. First of all, I'd like to ask broadly, are warrants issued by the judicial branch?
I believe currently.
All right, thank you very much. Now, what are the current requirements for national security letters to be issued?
Relevancy.
Relevancy to what?
Relevance to a investigation.
What kind of investigation?
Like a counterintelligence, counterterrorism investigation.
Okay, thank you very much. Moving down now, could you please clarify your mandate 4 specifically?
Yes. So our mandate 4 is that the FBI is not allowed to store information that is sent by a recipient that's additional to the foreign counterintelligence investigation of an illegal action and specific and articulable facts that we've set in place, or if the information is no longer relevant to an investigation.
All right, now did the affirmative team claim any harms or advantages from that mandate?
Yes.
Which ones, please?
We claimed that the relevancy standard was too low, and so that's why we're putting in a better standard for the NSLs to be issued.
When did the affirmative team claim that?
In harm 1.
All right, so could you please just quickly reread the tag for harm 1?
Massive amounts of national security letters are used purposely to bypass the courts and can tap anyone relevant to an investigation. The FBI misuses this information.
I see, thank you. Now, did the affirmative team read any evidence saying that the FBI misuses this information?
I don't believe so in our case, but we can bring evidence up.
Yes, that would be great, thank you. Now, under gag orders, would there be any problem in the status quo if you could actually review a gag order and get it removed?
That would be difficult, and you're putting the weight on the U.S. citizen then.
All right, but would there actually be a problem?
If it could be reviewed,
Yes.
if the information, if they correctly reviewed the NSL, yes.
All right, thank you very much.
Or, no.
Could you please repeat the tagline for your second advantage, please?
Yes. The gag orders cannot continue eternally, providing a balance between the government security and freedom of speech, lessening the burden on citizens.
All right, could you please repeat your third mandate?
Gag orders may be issued with a limit of 30 days. If the investigation needs to continue longer, the gag order must be extended by Foreign Intelligence Surveillance Court.
Thank you, and I have no further questions.
The most important function of government is to protect the people, and counterterrorism is a large part of that. The affirmative team has proposed a plan to put greater restrictions on government surveillance used for counterterrorism. Obviously, terrorist attacks put people's lives in danger. Thousands of people were killed in the 9/11 attacks alone. The Declaration of Independence specified the right to life, liberty, and the pursuit of happiness. The affirmative team's plan will weaken the protection for all three of these rights by making the U.S. more vulnerable to terrorist attacks. So just keep that in mind throughout this debate round. Let's address the affirmative team's case outline, starting with harm one. We have several points to make under the stock issue of significance. The first, their main point under harm one was that NSLs are being used to bypass the courts. Now, quite frankly, that's what NSLs are for. The whole purpose is they don't have to go through a court process which slows everything down. They can simply send a letter to a third party demanding that they hand over information. It's a much quicker and more effective process. So this isn't actually a harm. The second point I'd like to make is that these NSLs only deal with third-party business records, and the Supreme Court has ruled that people have no reasonable expectation of privacy or Fourth Amendment rights when it comes to third-party records, because they are voluntarily disclosed to businesses. When you do business with a bank, you give them certain information, it's no longer your private property, and they have the right to disclose it in a legal way. This is from Orrin S. Kerr, the case of the third-party doctrine from the Michigan Law Review. Quote, according to the Supreme Court, the Fourth Amendment does not prohibit the obtaining of information revealed to a third party and conveyed to him by government authorities, even if the information is revealed under the assumption that it will be used only for a limited purpose and the confidence placed in the third party will not be portrayed. In other words, a person cannot have a reasonable expectation of privacy in information disclosed to a third party. The Fourth Amendment simply does not apply. So the Fourth Amendment protects people from unreasonable searches and seizures. It doesn't cover third-party business records, so there is no problem. People's privacy rights are not being violated. And the third point I'd like to make is that it really doesn't even negatively affect these people for the government to have their information. It helps protect them from terrorist attacks, which is a good thing. It doesn't violate their privacy in any way. Life goes on as it did before if the government has your business records. Now, one more point I'd like to make is that they said under their first harm that this information is being misused by the FBI, but they never had any evidence, they never proved this point, and really their plan doesn't do anything to prevent that, so we'd like to know what this is really all about, and if they could provide some evidence, that would be helpful. So now, moving on to solvency under harm one. The first point I'd like to make is that they claimed under the harm that relevance is an extremely low standard. Well, I've already shown that that is enough because the Fourth Amendment doesn't apply to third-party business records, but their plan really wouldn't even solve this problem if there was a problem indeed, because all it does is limit it to agents of foreign powers, which still can be U.S. citizens. The relevance standard to the investigation is exactly the same. It just limits it to different people, but the actual standard is the same, so they wouldn't be able to deal with this issue with their plan. The second issue is that they're limiting, apparently, I believe mandate 2, they said they would have to go to a higher authority within the FBI to carry out these investigations. Well, it's still the FBI, and these people would still be aware of what is going on within the agency. So if these NSLs are being misused, just going to a higher authority within the same agency isn't going to make any difference. So this is another solvency issue under their plan. So now let's move on to the second harm, which is basically that the gag orders of NSLs violate our First Amendment rights. Now, I would actually like to read a piece of evidence to show that the First Amendment does not apply to this situation. One second, let me see this is from the court case Schneik versus United States from InfoPlease. Quote, the court held that reasonable limits can be imposed on the First Amendment's guarantee of free speech. No person may use free speech to place others in danger. In this case, we're talking about national security information. So if you're talking to people about the fact that you received an NSL, you would be putting other people in danger. So the First Amendment doesn't apply. The gag order in this situation is justified, so there is no First Amendment violation. Now, another point is that it really doesn't hurt these people to be under the gag order. They received an NSL, okay, so they can't talk about it. How does that really hurt them? And they read some evidence about people being hurt by the gag order, but just because these people were saying that doesn't really mean anything. Maybe they just didn't like that the fact that they received an NSL. It really doesn't prove their point, and they gave no reason why it would actually hurt them. And they also mentioned that people would have to lie about it. Well, if they never told anyone about it in the first place, why would they have to lie about it? If they did, that would be their fault, not the issue of the gag order. So there is no problem here. Also, I would like to bring up another point under significance, which is that NSLs can be challenged in the courts if the person who receives them believes that they are actually illegal. And let me find a piece of evidence on this I'd like to read. This is from Daniel B. Petro, The Working Paper War About Terror, Civil Liberties, and National Security After 9/11, Council on Foreign Relations from February 2009. Quote, the USA Improvement and Reauthorization Act of 2005 permitted judicial enforcement of requests. At the same time, it explicitly authorized judicial review, allowing NSL recipients to petition the courts to modify or reject the letter request to the non-disclosure requirement. So people can challenge NSLs in the courts if they feel that their rights are being violated. So there really is no problem if their First Amendment rights are being violated. So there is no issue here. So now moving on to solvency under Harm 2. Their plan really wouldn't make any difference even if there was a First Amendment issue, because their plan only limits it to 1 year. They can still use a gag order, they're just putting a 1-year limit on it. And 1 year after you received an NSL, why would you have any need or desire to talk about it? It happened a year ago. It's gone and forgotten, so their plan really wouldn't make any difference anyways. So now I'd like to address a last point. The affirmative, actually, moving on 1 minute to the advantages, really I'm not going to make any specific arguments because they're basically the flip side of the harms, so just to clarify that. So now to a disadvantage, which is that basically their plan will slow down the entire process of counterterrorism efforts, because they will be requiring them to go to a higher authority. It's just going to slow down the process. So let's just review what we've gone over. Under Harm 1, I showed that the fact that they're being used to bypass the courts really isn't a problem, because people have no Fourth Amendment rights when it comes to third-party business records. Also, it doesn't even negatively affect these people for the government to have their information. It simply helps protect them from counterterrorism. So by putting limitations on what these NSLs can be used for is only going to hurt our counterterrorism efforts. And one other point I'd like to bring up, actually this is a second disadvantage, is that they're limiting it to agents of foreign powers, which that's not really going to create any advantage, because agents of foreign powers can be U.S. citizens, so all they're doing is limiting who it can be used against, which is only going to weaken our counterterrorism efforts. Thank you, and I am now open for cross-examination.
Good afternoon.
Good afternoon.
All right, so first question, underneath your second significance point on our Harm 1, I think it was about the dealing with third-party records and Fourth Amendment rights. So is it still legal for them, do you still believe this stands if they're collecting illegal information with these NSLs?
You have not shown that they are using them illegally.
So if we could show this, would this point still stand?
People would still have no reasonable expectation of privacy. They would have no Fourth Amendment rights.
But if illegal information is collected from the NSLs, well, then how do they still have no rights?
The point is the records that are being obtained don't apply to the Fourth Amendment. It doesn't matter how they are being obtained.
Okay. Also, why are we pinning this on the U.S. citizen to go to the government and say, this is illegal and I don't believe that this protects my privacy with the NSLs if they think that the NSL is unfair with the gag order?
Well, you haven't even shown that NSLs are being abused.
Okay, thank you. With the Harm 2, your evidence underneath that, you read some evidence?
Yes.
Where was that from?
Let's see. Oh, about First Amendment rights.
Yes.
That was from Info, please.
From where?
Info, please.
What is that?
It's basically an online encyclopedia.
Okay, thank you. With the mandates, what was your overall argument for the mandates?
Basically, that it really won't make any difference, especially under the issue of the First Amendment, because you're putting a one-year limitation on it, and after 1 year, it really wouldn't matter anymore
Okay, you
anyways.
are aware that we're not putting a 1 year, but it's 30 days.
Oh, well, okay, I'm sorry, 30 days. Well, the same argument still applies. After a month, it would still be all over and forgotten.
Okay, thank you. And thank you, no further questions.
The first thing I'd like to do is remind the judges of the important balance between liberty and security. This is what the affirmative team is trying to do through our reform of national security letters. We're trying to balance your rights as Americans and your security in living in this country. And so this is why we have put out the affirmative team's, our plan. So the first thing I'd like to address is under harm 1, explaining about the misuse and the numbers and some of the important things surrounding national security letters. We read some evidence surrounding this in our 1AC, but in order to address the real facts, we have to have some more time to be able to examine the evidence. So first, this is from Liberty and Security in a Changing World from the White House on December 18, 2013. The FBI issued 21,000 national security letters in fiscal year 2012, primarily for subscriber information. NSLs are most often used early in investigation to gather information that might be linked to suspected terrorists or spies to each other or to a foreign power or terrorist organization. Non-disclosure orders, which are used with 97% of all NSLs, interfere with individual freedom and with First Amendment rights. The FBI currently issues an average of nearly 60 national security letters per day. So then I'm going to talk about 4 significant examples of misuse and tell you why our plan is solvent for this misuse. First, this is national security letters being used in a blanket fashion to gather data on 3,860 phone numbers. This is from Reclaiming Patriotism, a call to reconsider the Patriot Act, National Security Letters, 2009. FBI officials and special agents in charge improperly issued blanket NSLs in 2006, seeking data on 3,860 telephone numbers. None of these blanket NSLs complied with the FBI policy, and 8 imposed unlawful non-disclosure requirements on recipients. Moreover, the blanket NSLs were written to cover information already acquired through exigent letters and other informal responses. So then the next one is that NSLs are used to obtain private information. This is from Frequent Errors in Secret Record Requests from the Washington Post on March 9th of 2007. Inspector General Glenn Fine found that the FBI obtained full credit reports using a national security letter that could lawfully be employed to obtain only summary information. In an unknown number of cases, third parties such as telephone companies, banks, and internet providers responded to national security letters with detailed personal information about customers that the letters do not permit to be released. Then, national security letters were used as a cover-up to bypass the courts, as Dan Egan tells us in The FBI Found to Misuse National Security Letters from March 2008. This is kind of a long piece of evidence in order to explain it, so I'll just paraphrase, basically by saying that the court had said they submitted a court order to request this information, and the court said, no, we're not going to allow you to issue it. So they just went to the FBI and issued a national security letter for information they should have gotten through the court, so it was a cover-up. Then the last one is that the FBI keeps and stores information that is additionally sent to NSLs that shouldn't have been sent from the person who received it. So in a violation in 2006, the FBI requested an email header for information from 2 email addresses used by a U.S. person. In response, the email service provider returned 2 CDs containing the full content of all the emails. This is not information that can be collected under national security letters. This is significant misuse in national security letters. So this goes directly against what the negative team has brought forth. We agree with the negative team that national security letters, when used properly, for getting third-party record information. That is correct. National security letters used in that way is good. We agree with the negative team that that is constitutional. We're not challenging that. It's the stuff that the national security, that the FBI can gather outside of that with national security letters, as we've already shown that they're doing. So then to look at the they're saying it's still within the FBI and that it's just a higher authority. Well, I'd like to point out here that the negative team never contested our enforcement. which is the internal investigation section. They are an agency which works within the FBI in order to look against different places in the FBI and make sure that there isn't misuse. They don't currently look over national security letters, so we are going to bring them in and allow them to be able to do that. We feel that that's the best enforcement. So these higher level officials will review them, not the special agents in charge, but the higher level FBI officers will actually issue them. But then the internal investigation section will come in and enforce to make sure that there's no misuse. So then, to clarify under the mandates, I'd just like to explain our mandates quickly. The first one is changing the standards of national security letters. Before 9/11, this is the standard that we had, that it had to be specific and articulable facts, giving reason to believe that the person is an agent of a foreign power or is a foreign power. That's what it was before 9/11, and then after 9/11, the Patriot Act changed it so that it just had to be relevant to an authorized intelligence investigation. So what we're doing is narrowing those standards back so that we get the information that we actually need to be able to stop terrorists. And this goes, again, with what the negative team has said under their disadvantage, saying that there will be more terrorist attacks. No, we're narrowing it so that it will get better. And I just realized that I skipped harm 2, and I think that's a bad idea. So I'm gonna skip back up to harm 2, I'm sorry. So the harm 2, the affirmative team was contesting this, saying that national security letters, the gag order will cause people to possibly release information and that they can challenge national security letters in court. Now, the recipient of a national security letter doesn't necessarily know all the misuse that's going on behind it. So we can't expect that court review to be our enforcement in the status quo. So we need something better. That's why we're passing our plan. And also, we interfere with political ability to be able to speak if people are under a gag order under national security letters. Let's see. That piece of evidence is right here. This is from Jerome Tusil, FBI still misusing national security letters from 2009. Unable to speak about their experiences as the subjects of national security letters, recipients of such letters, including business people and librarians, can only stand on the sidelines while discussion is conducted in theoretical terms. So what this is saying is that their political rights are being squelched by being stuck under the gag order for a long time. We read an example of 3 years, for example. So what our plan will do is provide that balance that I talked about between liberty and security. We'll be giving people the ability to speak about whether it's wrong or right or conduct their business in political terms and keep them from lying, but also have that government secrecy, and if it needs to be extended, it can be by the Foreign Intelligence Surveillance Court. So I'll spend the remainder of my time talking about the plan. I would also like to point out here that, again, the negative team never addressed our enforcement, which is helping with our solvency, and under Mandate 4, we're allowing that helps with our solvency as well, because the information that is additionally collected won't be able to be used. The information that's not legal won't be able to be used. Then with the disadvantages, again, there's plenty of people, because we're still allowing at least one in every state of the high-level FBI officials to be able to issue national security letters. Backlog isn't an issue. And I urge you to address the second disadvantage of balance between liberty and security and keeping us safe. So thank you, and I now stand open for cross-examination and further clarification.
Good evening.
Hi.
Under harm 2, you mentioned that people don't have the information they need to be able to challenge these NSLs. They don't know that their rights are being violated, correct?
In some of the cases which I read,
Okay, if they don't even know that their rights are being violated, then why would they want to challenge it? How is it negatively affecting them?
well, in some cases it does negatively affect, okay, they might not know what's going on the other end, but it's still keeping them politically from being able to speak, if that makes sense. So the gag order it's kind of a separate issue in that regard.
All right, now, about people having to lie about it, why would they have to lie about it if they never told anybody about it in the first place?
Well, for example, in order to obtain the information within their business, there would obviously be question as to why they would need to obtain certain information, say records, so that it would force them to lie.
Would you agree that NSLs are probably received by the manager of a company, not a lower employee?
I'm not willing to 100% agree with that.
Do you have any proof?
I might, not with me.
Okay, thank you. Now, about the misuse of NSLs, I believe you read a piece of evidence saying there were 8 violations.
That was just talking about the 8 violations that related to the letter in regards that collected
Okay.
telephone
But
numbers.
can you
Those
give
or
us-
telephone
But
records.
can
Those
you
were
give us
outside.
numbers to show how many violations there were during a specific period of time?
I don't have that with me, but we might be able to talk about that further later.
Okay, thank you. Now, your enforcement, what exactly was this department that would be overseeing these
It's
NSLs?
the internal investigation section.
Okay, so this already exists, correct?
Right.
But they're not currently inspecting the use of NSLs?
Right.
Do you have any evidence to prove that?
Yes.
Can you read it, please?
I don't have that with me
Oh, not
right
with-
now.
Yes, later.
Sorry.
Yes.
I can.
Thank you. Now, you said that you said that these NSLs are being used to bypass the courts and obtain information that couldn't be obtained through the courts.
Right.
How is that actually a problem?
Okay,
Could it be
I
that there
understand
was certain information
That
couldn't-
Okay, do you want, sorry.
Could it be that there was certain information that couldn't be obtained with a court order, but could be obtained with an NSL?
There is, in order to gain more complex and detailed content information, you have to go through the court and receive that higher level process.
Okay,
And when
but
they couldn't get that approval,
currently,
they just went to national security
NSLs
letters.
cannot be used to obtain the contents of communications, correct? That would be
Correct.
illegal. Okay, so that would be an issue of enforcement, not the mandates, or not the actual mandates of your plan.
Sorry, rephrase the question?
The only way you could stop violations would be enforcement, correct?
Yeah, well, I'm not sure I 100% understand your question, so
Okay,
I think,
thank you. No further
well, thank you.
I would like to begin this speech by just saying that we agree with the affirmative team on one point, and that is that national security letters are vital to our counterterrorism and counterintelligence investigations. However, we'd like to also point something else out. That is not the sum total of everything national security letters can be used for. The problem is national security letters are also used for criminal investigations, and as we'll bring up later in a disadvantage, the affirmative team's plan eliminates their use in this regard. So I'm going to start off now, however, with the arguments brought up under the harm, and I thank the affirmative team for clarifying exactly what the first harm is, that it's about misuse and not about the argument under third-party doctrines. However, we now have, since we have this clarity, we can bring up some better targeted arguments here. First of all, there's a significance problem because this misuse is not actually intentional. I believe the affirmative team actually read some evidence to this effect. And this is a response to DOJ, Department of Justice, Inspector General's report on FBI's use of national security letters from the FBI. The Inspector General conducted a fair and objective review of the FBI's use of a proven and useful investigative tool, as certified the Director Robert S. Mueller III. And his findings of deficiencies in our processes is unacceptable. We strive to exercise our authorities consistent with the privacy protections and civil liberties that we are sworn to uphold. While we have already taken some steps to address these shortcomings, I am ordering additional corrective measures to be taken immediately, Mueller said. Importantly, the Department of Justice, DOJ, found no deliberate or intentional misuse of authorities, whether NSL satiates or Attorney General guidelines. So basically, there's 2 points here. One, these problems are already being worked on, and so there's a serious doubt the affirmative team needs to show that the NSLs are currently being misused. Also, talking about this, we have a significance issue. If these violations are unintentional, then let's face it, people make mistakes. These are simply going to have to continue. And so what we have here is a significance issue. Moving down now, we also like to point out that the affirmative team brought up that we never challenged enforcement. However, we didn't actually understand what the first harm was. There was almost several taglines in the first affirmative constructive, so we had no opportunity to address enforcement because the harm was unclarified. Also, we'd like to point out that it has been an unproven assertion that this enforcement is not already in the status quo. This agency obviously already exists because the affirmative team has not mandated it. So basically, until the affirmative team actually proves that this agency currently does not review national security letters, and at this point, we'll only have one speech to respond to that argument, it's a very late argument, then we have an insolvent plan. Because if there's misuse in the current system, then there's going to be the same exact misuse under the affirmative team's plan. These arguments, by the way, all address Advantage 1 and the mandates. Also, under the specific issue of storing over-responded information, I'd like to point out that this is not misuse by the FBI, because the affirmative team has not shown that this actually violates any code or law. And so the claim that this is part of the misuse under the harm needs to be proven that this is actually in violation. We've also like to point out that under this harm, we have a point that this doesn't actually harm you. Basically, how does it hurt you for the government to have your third-party business records? The affirmative team admitted that there is no Fourth Amendment contradiction here. The third-party doctrine allows the government to go and get that information by a national security letter. So the question remains, how does it harm you? If basically the only claim here is that there is misuse, then we've seen that that misuse will not be corrected under the affirmative team's plan, and that the information actually poses no threat to you personally. And so how is this misuse actually harming civilians? Now addressing harm to and advantage to. The affirmative team has basically claimed that court review being the burden being upon you as the individual to go to the government and basically challenge this order is unnecessary, that it should be the government that has to prove these orders. I'd like to point out, however, in all normal court proceedings, it's the plaintiff that brings the court to suit. Basically, if I go rob somebody, I don't go to court and say, okay, we need to have a court hearing because I robbed somebody. It is the job of the person who has been robbed, who has been wronged, to come back to the court system, in this case, to the government, and address this issue. Once again, with court review currently being in the status quo, which the affirmative team has not challenged, we have no problem under harm to. Also, I'd like to point out that the First Amendment argument that we brought up has not been directly contradicted by the affirmative team. Basically, we cannot use our First Amendment rights to endanger someone else. The affirmative team did not contradict this statement. If we look at that and look at what it means that in this case, in national security cases, we have no First Amendment rights to go and reveal this information. And so we have a gag order. And even if there is a First Amendment implication, we have a review court. Also, I'd like to point out that the argument was dropped about why this actually impacts you. We pointed out that basically, unless you're dropping hints that you've received a national security letter, there's no reason for people to be asking about that. And so the impact that was brought up in the 1AC about it's terrible, I have to lie to everybody I know, is basically non-existent. And the affirmative team never addressed that in the last speech, so that argument flows to the negative team, and we see that there's no impact under the second harm. Moving down under the mandates, all of these have been addressed by arguments under the harms and advantages, so I won't get into them specifically. I believe the last affirmative speaker said that we drop mandate 4, which is basically storing information. That was partially addressed, however, under our argument about the third-party doctrine and governments being allowed to actually obtain that information. We didn't address it specifically, however, the argument is still related. Now, I believe at this point, actually 4 disadvantages that I need to bring up. First of all, disadvantage 1 is a slower process for issuing national security letters, and my partner brought this up in his first speech. Basically, we have the agency that issues these letters is still the FBI, so there's no change there. However, it's only now a step higher within the Federal Bureau of Investigation, which means, of course, that even though there are 60 national security letters being issued a day, they're now going through far fewer hands. And so what we have here is a slower national security process, which is, as the affirmative team point out, the purpose of national security letters. Moving down to disadvantage 2, I'd like to point out that this is now only counterterrorism and counterintelligence investigations related to a foreign power. What about domestic terror investigations? The affirmative team's plan completely eliminates the use of national security letters for this purpose. Disadvantage 3, as I brought up in my introduction, now national security letters cannot be used in criminal investigations. So, once again, another eliminated use of national security letters. The final disadvantage is that the Foreign Intelligence Surveillance Court is going to be slowed down. 60 orders a day, and now every 30 days the government's going to want those orders reviewed. The Foreign Intelligence Surveillance Court now has to do all of that, the affirmative team has not provided us any reason to believe that the Foreign Intelligence Surveillance Court can handle that load. Thank you, and I now stand open for cross-examination and further clarification.
Hi, first, a couple questions for you. First, under the piece of evidence you read from the Department of Justice, I believe, what was the date on that evidence?
I'm afraid that I do not actually, it looks like the date has been cut off, I'm sorry. We'll have to get that for you later.
Okay, that would be extremely important, so if you could bring that back up for me,
Yes.
that would be great. Next, could you restate your violation argument, possibly under harm 2?
Harm 2. I'm not
Right after the internal investigation section argument, you made an argument about violation?
Under harm 2?
Yes. Or if it wasn't under harm 2, correct me.
All right, I believe we made an argument under harm 1 that basically the affirmative team's plan would be insolvent, that the enforcement has not been proven by the affirmative team to not already exist within the status quo, and so if there's misuse currently, there's
Okay.
going to continue to be misuse.
Okay, thank you. How would you agree that national security letters are issued for counterintelligence, relevant to counterintelligence purposes now?
No, not solely.
Okay, could you explain, please?
I believe that the purpose of national security letters, since they're actually issued under multiple acts dealing with criminal intelligence, actually collection of foreign intelligence matter, is actually a very broad tool used in
Okay,
criminal
but
investigations.
section 505, does it not say counterintelligence?
I believe actually in the affirmative team's plan, they said specifically 505, however, the affirmative team included all statutes governing national security letters.
Okay, but are criminal cases counterintelligence?
No.
Well then, does your disadvantage 3 stand?
Yes, I believe that that's the point, that basically the affirmative team's plan would be eliminating national security letters for criminal investigations.
Okay, well, we can argue about that later. Thank you. Your fourth disadvantage was related to the Foreign Intelligence Surveillance Court being able to handle reissuing.
Yes.
Okay. Do you have any evidence to prove that it'll be too much?
Not with me. I believe we can bring that up, however.
Okay. Let's see. Do you have... let me see. Did I say that you dropped the argument under Mandate 4?
That was the impression that I was under. If I am mistaken, I'm sorry.
All right, thank you. I think that is it. No further questions.
All right, thank you.
As put by the Heritage Foundation, a threat to America's security is a threat to Americans' liberty. This is the stance of the negative team. The affirmative team's plan does not further protect our rights because there is no violation of the First Amendment nor the Fourth Amendment. It will only weaken the protection of terrorist attacks within the United States. Let's start by addressing the first point, which is basically the issue of harm 1 and advantage 1. We have a couple points under significance. The first is that the misuse is actually not intentional. My partner read evidence to show that these violations were actually unintentional. They were related to human error within the agency, so there actually isn't any significant problem here. And secondly, the affirmative team really read no solid evidence to show that there are a significant number of violations. They read evidence saying in one situation there were 8 violations. They cited a couple other situations, but if it's only a handful, there really is no significant problem. Secondly, if it doesn't violate our privacy rights under the Fourth Amendment, there really is no significant problem. And the affirmative speaker pointed out that we dropped Mandate 4. We did not drop Mandate 4. We pointed out that people have no reasonable expectation of privacy in third-party business records. So basically, requiring the government not to store people's information isn't going to result in any significant advantage because people have no Fourth Amendment rights when it comes to those records. So there is no privacy issue there. So now, moving on to the issue of solvency, which is basically basically the issue of their enforcement. Now, they have read no evidence to show that this inspection is not already in the status quo, so we really don't know if there is any problem. And jumping back one moment to the first point that we made under the harm under significance, the evidence that my partner read also said that these violations were being solved because of these inspections that were going on. So again, there is no problem. So now moving on to the second harm. The affirmative team has not challenged our point that there is no First Amendment violation. The Supreme Court has ruled that people cannot use free speech to put others in danger. This is national security information, so these gag orders are justified, and this really wasn't contested by the affirmative team, so it should flow to the negative. So there is no harm here if the First Amendment is not being violated. And it really doesn't negatively affect these people to be under the gag order. They simply can't talk about it, but if they didn't tell anyone about it in the first place, they would have no need or desire to talk about it. So now, and then they would not have to lie about it. Now, under solvency, actually one more point, as my partner pointed out, these NSLs can be challenged in the courts, so there is no problem, there's no need for putting limits on them. And under solvency, they're putting a 30-day limitation on it. Now, after 30 days, it happened a month ago, it's gone, it's over and forgotten, they would have no need to talk about it after that amount of time. And if they never told anyone about it in the first place, there really would be no issue. But even if there was an issue, their plan would not fix it because they're only putting a 30-day limitation on it, which will not make any difference. So even if there was a problem, their plan couldn't solve for it. So now moving into the issue of the 4 disadvantages. The first is basically that it's going to slow down the entire NSL process. And this is a significant disadvantage. When it comes to counterterrorism, we need to be able to act quickly. They're going to place a bunch of restrictions, like having to go to a higher authority within the FBI, which again, as we said before, will make no difference. It's still within the FBI, so it really doesn't change oversight at all. Disadvantage 2 is that they're basically limiting it to domestic surveillance. Well, limiting it to agents of foreign powers. Well, what about domestic threats to national security? I'll read a piece of evidence to show that a lot of terrorist attacks were domestic. This is an article from the Heritage Foundation published in 2012. Quote, based on Heritage research, at least 50 publicly known Islam-inspired terror plots targeting the United States have been foiled since 9/11. 47 were thwarted due to the conceded efforts of intelligence and law enforcement. And this article is about homegrown terrorist plots. So now moving down to disadvantage 3, which is basically that they're excluding the use of national security letters from criminal investigation, which again, it's just limiting them even more, which is a significant disadvantage. Disadvantage 4 is that it's basically going to slow down the Foreign Intelligence Surveillance Court by requiring review of these NSLs, which is going to slow down our entire counterterrorism policy. This is from Liberty and Security in a Changing World. Quote, a requirement that NSLs must be approved by the FISC would pose a serious logistical challenge. The FISC has only a small number of judges, and FBI currently issues an average of 60 NSLs per day. It is not realistic to expect the FIC as constituted to handle that burden. So our rights are not being violated, and the affirmative team's plan will produce 4 significant disadvantages. For these reasons, I strongly urge for a negative ballot.
All right, so starting off with the stock issue of significance. For the first point underneath the significance, the evidence that the negative team supplied us with about the misuse is beyond intention. They didn't even have a date on the evidence. And the evidence that we have supplied for misuse in the current system had dates, and we showed a lot of examples of the misuse. We had 4 examples, significant examples of misuse for NSLs in the current status quo. And this is why we need to change it to make it better. This is why we want to balance security and liberty. There is a significant number of violations in the current status quo. Moving on to the next point in significance, there's no privacy for the third party for the information that's collected. Well, Judge, we agree with this. If the NSLs collect information it's supposed to, we agree with it. But it's when they misuse the NSLs, when they collect information that they're not supposed to collect. That is when we disagree. That is when we have to put the stopping point, and we need to change it so that we can balance security and liberty. It is protected by the First Amendment. It's against our privacy when they collect information that they are not supposed to. Going into the stock issue of solvency, for the first point, the internal investigation section is not currently reviewing NSLs, and I would like to read some evidence. From Charles Doyle, Senior Specialist in American Public Law, National Security Letters and Foreign Intelligence Investigations, Legal Background, January 3, 2014, from the Congressional Research Service. Quote, the U.S. Patriot Act expanded by FBI, issuing authority beyond FBI headquarters officials to include the heads of the FBI field offices, special agents in charge, and eliminated the requirement that the record information sought pertain to a foreign power or the agent of a foreign power. And this is where this next paragraph is where it shows us that the internal investigation section is currently not reviewing NSLs. The new section had a non-disclosure and a safe harbor subsection, but no express means of judicial enforcement or penalties for improper disclosure of a request under the section, unquote. So this is showing that there is currently no review for these non-disclosure requirements for the NSLs. That is what this evidence is proving. And also, I would like to read some evidence on how the internal investigation system section has been effective in the other parts of the FBI that it has been overseeing. From review of the Federal Bureau of Investigation's disciplinary system, the U.S. Department of Justice Office of the Inspector General Evaluation and Inspections Division, May 2009. Quotes. We found FBI investigations of staff misconduct generally were thorough and conducted in a consistent manner. We also found that the timelessness of misconduct investigations improved during the 3-year period of our review, unquote. So this is showing that the internal investigation section was doing good in the other areas that it has been reviewing. So moving on into the next point of solvency, that we cannot use our free speech unless, if it's going to be detrimental on the security of the people. Well, Judge, our plan is not going to be detrimental on the security. It's going to balance security and liberty. After 30 days, if the information is still relevant to an investigation, you can extend it if it's still relevant. Therefore, the information will not just be released to terrorists after 30 days. It would still be kept a secret if it was relevant to an investigation. Going into the next point of solvency, it can be challenged in the courts by the citizens that receive the non-disclosures. We don't want to pin this on the U.S. citizens, and my partner read evidence the U.S. citizens might not know if they have received something that's illegal or that's not fair for their privacy and their liberty. On the next point, after the 30 days, they need to why do they really need to talk about it? Why is it important? Obviously, in our first 1AC, we read evidence of a person who had been kept under non-disclosure requirement for over 3 years. That is more than 30 days, and that person still cared after 30 days. So going into the first disadvantage, that we have the internal investigation reviewing, and it's not going to be a slow process because there are the internal investigation sections have many places and all around the United States, and then the disadvantage 2, disadvantage 3, and disadvantage 4 will not come about with the affirmative team's plan. Their evidence they supplied in disadvantage 4 was not relevant. Thank you, and we urge for an affirmative ballot.
I'm going to begin this second negative constructive by first of all addressing harm 1 and advantage 1 together, and then tagging the specific arguments under each one of those, and addressing harm 2 and advantage 2 together, and tagging the specific arguments and stock issues under those as well. And then finally addressing the disadvantages. We will not be addressing specifically the mandates since those arguments have been covered under the other issues. Starting with harm 1, and this has a lot of arguments under it, so I'm going to start off with the arguments dealing with significance. First of all is the issue that we've pointed out that this misuse is unintentional. And so the overcollection is still going to happen under the affirmative team's plan, and so there's no significant harm here. Now, I'd like to point out that the affirmative team's evidence in the second affirmative constructive actually made this point for us. And so the issue of having no date is not actually a problem, and I will say that that evidence did not have a date, and I apologize for that. Also, I'd like to point out that if the violations were being solved then, why would they suddenly stop reviewing this a few years later? More than likely, the same review is still process and the same procedures are still in place that were being enacted then. And so once again, solving solvency. Now, talking about significance once again, we've showed that it doesn't actually harm you. Basically, since this information is legally collected under the Fourth Amendment, and the Fourth Amendment is designed to protect our privacy, how is having this information actually harming you? If the only abuse here is mainly unintentional, then that same abuse is going to continue, first of all. And second of all, it's not actually a significant harm, because if they're not intentionally misusing your information, and the affirmative team has provided no evidence that there's actually been damage to persons, we'd like to ask, where's the significance of the first harm and first advantage? Now, moving down to the stock issue of solvency, addressing harm one and advantage one, enforcement. And I'm honestly not sure how the last speaker addressed this, whether it was addressed at all. If not, then obviously that flows to the negative team, and the affirmative team's plan is not solvent. However, if it was, I'd like to point out that the evidence I believe that they were using to address it didn't actually say that the enforcement, this board, didn't currently oversee national security letters. The evidence talked about judicial review and maybe indirectly mentioned the board. However, there was no direct refutation of the negative team's arguments, and honestly, it's too late in the round because this is our last speech, our last chance to respond to the affirmative team. Now, moving down into the issue of inherency under harm one, and this is once again that the violations are already being solved. There's been procedures put in place to fix these violations. This has not been contradicted by the affirmative team with any sort of evidence, and so the status quo is already solving. This problem is not inherent. Now addressing harm to and advantage to. Our first argument under significance was dropped in the second affirmative constructive. This argument was that there was actually no damage to you from this gag order. The second affirmative speaker never addressed this issue. Therefore, this issue flows to the affirmative team even though the last speaker did address it. And this is significant because if there's no actual damage to you, then what's the point in passing the affirmative team's plan? Moving down under the next argument under significance with the harms, or these harms, we've pointed out that you have no First Amendment protection in these arguments. This is not a solvency argument, this is a significance argument. If there's no actual protection, then it's not damaging you to have this gag order. Talking about significance finally, we've pointed out that the court can review this evidence. The dates here are immaterial because after the Patriot Act was passed, which was in 2001, that was what the affirmative team's evidence referred to. This, you can initiate a review. That's what most other court-related areas would have you do. And so what we have here is, once again, no significant problem since you can challenge these gag orders. Now I'd like to address the disadvantages briefly. First of all, slowing the issuance by requiring only higher-up FBI agents to issue these orders. I'd like to read here evidence from the statement of Valerie E. Caproni, General Counsel of the FBI, National Security Letters Reform Act of 2007, hearing before the Subcommittee on Constitution, Constitution, Civil Liberties, and Civil Rights, Civil Liberties of the Committee on the Judiciary, House of Representatives, April 15, 2008. In terms of importance of national security letters, they are critically important to our ability to do our job. By getting records with NSLs, things like phone records and bank records, those are the basic building blocks of any investigation. Judge, these national security letters, and this is under most of the disadvantage, are critical to our investigations. Disadvantage 2 has already been addressed, or is basically that they'll be limited to foreign investigations instead of others, and the FISA court will be slowed down. Thank you very much.
So we've come to the last speech of the debate, and I have the pleasure of showing you how the affirmative team is significant and solvent through our case. The negative team has brought against a variety of arguments that I would do my best to address under significance and solvency, but a lot of the arguments cross over each other. So first, under the first harm, we have read throughout this round that there is a vast majority of abuse. And the affirmative team basically contesting this is saying that there's no, national security letters allow data that is allowed under the Fourth Amendment. Yes, but the examples that we read were outside of what is allowed with national security letters. This basically means that if they were legally collected, then it's good for the purpose of catching terrorists. But if it's illegally collected that way, then it shouldn't be happening and it needs to be fixed. Now, the negative team has said, well, you could go to the court and try to get it appealed. Well, while that's true, the person who receives a national security letter might not know the variety of ways that it was abused. So although having court repeals are good in the status quo, saying that that will completely be able to hold the problem is not accurate, as we've read evidence saying there is misuse. And then continuing on with solvency, I'd like to address our enforcement, just make it really clear what actually we read in that last evidence in the first affirmative rebuttal. We read evidence saying that there is no enforcement. Enforcement by CCA standards is basically saying, is the plank of the plan which provides punishment for breaking the specific rules of the plan. So we laid out those 4 rules, and our enforcement will be the internal investigation section. That evidence said that national security letters have no enforcement in the status quo. That means the internal investigation section will be coming in and providing that enforcement that we need to make sure that this misuse is not happening anymore. So then to talk about harm 2, and there's been a lot of debate back and forth about harm 2. This is where the huge impact is for you as the judges and for the rest of you here watching this round. The important part is that whether it's for 3 years or 6 years or 10 years, your First Amendment rights are at stake under this harm. And we read evidence to prove this, and we also read evidence proving that politically you can't speak. And the Founding Fathers found this principle of having freedom of speech important enough that they put it in the Constitution, and they worked hard to be able to gain this freedom of speech. So it's extremely significant that we maintain that. And that's why we put in this provision to maintain the government secrecy, and the balance, again, is our rights. So the affirmative team is, again, seeking to balance our security and our liberty, which we're not violating security. We're making things more specific so that we can catch terrorist attacks even better and have our rights. And then I want to address the disadvantages really strongly here, because I feel like people have been running out of time and the disadvantages are kind of getting skipped over. So for the disadvantages, the first one and the fourth one deal with slowing down the process. We're not slowing down the process. There are 54 officials who will be able to issue national security letters. And the internal investigation section is covering the FBI all over the country. So it won't be slowing down the process of issuing national security letters. And if the standards are narrowed, then in theory, national security letter numbers, how many need to be released or issued, will actually go down. And then under disadvantage 4, the evidence that the negative team read would overrun the court as if the court were issuing national security letters. That's not what our plan does, so that evidence doesn't stand. Under disadvantage 2 and disadvantage 3, these aren't significant either, because national security letters are for counterintelligence in the status quo, not criminal investigation. That's for disadvantage 3. And for disadvantage 2, the evidence that the negative team read to support that said that those were Islamic attacks grown in the United States. That would be an agent of a foreign power. Therefore, it would be covered under our plan, and national security letters would be used to be able to investigate and help stop those types of attacks. So again, we are solvent through our plan. We will bring about these advantages. We will be able to help restore your rights and also reduce the misuse that's happening in the status quo, that information is being collected illegally that should not be. So I want to thank you for your time, and thank you for judging, and I strongly urge for an affirmative ballot at the end of this round.